Judgment in the appeal DB and the Chief Constable of Police Service in Northern Ireland.
Lord Kerr will give the judgment to the court.
In Northern Ireland, flags matter. They are emblems and symbols of traditional loyalties and allegiances. When, therefore, on the 3rd of December 2012, the Belfast City Council decided that the Union flag would no longer be flown over Belfast City Hall every day, but on certain designated occasions only, a wave of protests was sparked, which continued for a number of months. This appeal is concerned with the reaction of the Police Service of Northern Ireland to those protests. One of the main forms of protest was a parade or procession from East Belfast to the city centre. That procession passed through an area of Belfast known as the Short Strand. That is a nationalist area in the sense that many of its residents believe in or are perceived to believe in a united Ireland. Their views were considered to be antagonistic to those who are marching to protest about the decision to reduce the number of days on which the Union flag was flown. On that account, violence was a virtually invariable feature of the passage of the procession through the Short Strand. Attacks were made on residents of the area and on their homes by some of those taking part in the parade. The holding of processions or parades has long been a troublesome aspect of public life in Northern Ireland. Before 1998, decisions as to whether parades should be permitted to take place were made by the police force. Inevitably, this gave rise to controversy and accusations of partiality. The Public Processions Act of 1998 sought to change all that. It placed responsibility for the management of parades in the hands of an independent body called the Parades Commission. The Act also imposed a duty on anyone proposing to hold a public procession to give advance notice to the police. Most importantly, so far as concerns this case, the Act made it a criminal offence to organise or take part in a public procession of which notification had not been given. None of the parades associated with the protests at Belfast City Hall was notified to the police. The appellant in this case was and is a resident of Short Strand. He took judicial review proceedings to challenge the failure of the police service to stop the parade. Mr. Justice Tracy in the High Court in Belfast held that the police had failed to appreciate the full extent of their powers to stop an unnotified parade. The Court of Appeal allowed an appeal against that decision. This court unanimously allows the appeal against the Court of Appeal's decision. It should be said at the outset that the PSNI, the Police Service of Northern Ireland, faced formidable problems in dealing with these protests, and that they deployed considerable resources in their efforts to deal with them. This case is not about the sincerity and authenticity of those efforts. It is about whether PSNI was sufficiently aware of the full range and scope of their powers. Participating in an unnotified parade is a criminal offence under the 1998 Act, and the police therefore had the legal authority to stop the parades from taking place. Whether they would have done so if they were fully cognizant of the extent of their powers is another matter. It is entirely conceivable that they would not have taken a different course if they had fully appreciated the extent of their powers. But that is not the issue. The critical question is whether they recognise that they had the power under the 1998 Act to stop the parades. Plainly, they did not. Moreover, the police wrongly believed that they were obliged by Article 11 of the European Convention on Human Rights and Fundamental Freedoms to facilitate protests, even if these were technically illegal. To the contrary, they had an inescapable duty to prevent, where possible, what were plainly illegal parades, and to protect those whose rights under Article 8 of the Convention from being infringed. In general, a decision to disperse a parade or protest which has not been notified will not infringe Article 11.
Court is adjourned.